Good afternoon. I'll now invite the Honorable Deputy Governor to say prayers.
Thank you, Madam Speaker. Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations for the glory of thy name and for the safety, honor, and welfare of the people of these islands. Bless our sovereign lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all of the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of our islands, the Premier, the Speaker of the Legislative Assembly, the Leader of the Opposition, Ministers of the Cabinet, ex-official members, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for in thy great name's sake. Let us say the Lord's Prayer together. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make his face shine upon us and be gracious unto us. The Lord lift up his delight of his countenance upon us and give us peace now and always. Amen.
Please be seated.
Administration of oaths or affirmations.
None.
Reading by the Honourable Speaker of messages and announcements.
We have received apologies from the third elected member from the District of West Bay. The Chair would also wish to welcome the former Mr. Speaker to our Parliament and trust that it would ignite some new members for your good self.
Presentation of petitions.
None.
Presentation of papers and of reports. The Development and Planning Amendment Regulation 2017 to be laid on the table by the Honourable Minister of Planning, Lands, Agriculture, Housing and Infrastructure.
I recognize the Honourable Minister responsible for planning.
Thank you, Madam Speaker. As I had advised and requested prior to this, the original draft Development and Planning Amendment Regulations 2017, I wish to withdraw. And with your permission, I beg to lay the new draft Development and Planning Amendment Regulations 2017. And just to advise that the government motion will remain the same, because this is simply a replacement draft of the original one that I had tabled. So with your permission, I'd like to do that. Thank you.
Permission is granted, and for clarity of members, what is being laid will supersede the original that was laid. Please ensure that all members have copy of the new replacement.
Questions to Honourable Ministers and members of the Cabinet.
None.
Statements by Honourable members and ministers of the Cabinet.
Recognize the Honourable Minister for Finance.
Thank you, Madam Speaker. Madam Speaker, the Legislative Assembly debated and considered the Public Management and Finance Amendment Number 2 Bill 2016 during its current meeting. Once the bill has been passed into law, Madam Speaker, Section 8 of the law will allow government, statutory authorities, and government-owned companies, otherwise known as SAGCs, to make additional repayments of debt, that being additional to the amounts that are required to be made in a fiscal period under existing loan agreements, without such additional payments causing an increase in the debt service ratio. Madam Speaker, the government intends to make additional equity investments not exceeding 10 million Cayman Islands dollars to SAGCs during the current 2016-17 financial period. The purpose of making additional equity investments in certain SAGCs is to enable those SAGCs to undertake debt principal repayments beyond the minimum amounts that those SAGCs are legally obliged to repay during the current fiscal year. The government shall write to relevant SAGCs to make it clear that the additional equity investments received from government should be applied to the debt principal repayment and to no other purpose. The advantage to the SAGCs receiving an additional equity investment from government and applying that amount to debt repayment is that its interest expense during the 2016-17 financial period will be reduced from its previously budgeted amount. Madam Speaker, beyond the 16-17 fiscal year, the SAGC's interest expense will also be less than previously forecasted. Madam Speaker, the advantage to the government of its intended additional equity investment to SAGCs is a further decrease in the overall debt position of the entire public sector by an approximate amount of CI $10 million and lower debt servicing and net debt ratios in future fiscal periods, assuming that no new borrowing or material deterioration in government's revenue occurs in future fiscal periods. Madam Speaker, loan agreements that the central government itself has entered into in previous years with respect to its borrowings prohibit early repayment of debt or all have make-whole provisions for any additional repayments of debt beyond the amounts specified in those loan agreements. It is for this reason, to avoid material penalties, Madam Speaker, that the government did not find it possible to make additional repayment on its own debt. Madam Speaker, it is important that I make the point that this approximate 10 million CI dollars of additional debt repayment represents good use of the government's funds because it will be used to pay off the country's debt that has to be paid off eventually. Accelerating those repayments will result in reduced loan interest expense for the country going forward. Madam Speaker, based on outstanding loan balances that existed as at the 31st of December 2016, the government intends to make the following equity investments to SAGCs with the instructions that SAGCs use those funds received to make additional debt principal repayments. Cayman Airways, an amount not exceeding 1 million Cayman Islands dollars. Cayman Islands Development Bank, an amount not exceeding 6,280,000 Cayman Islands dollars. The Health Services Authority, an amount not exceeding 1,265,000 Cayman Islands dollars, and Cayman Turtle Center, an amount not exceeding 1,412,000 Cayman Islands dollars. Madam Speaker, if you would allow me to explain briefly. Madam Speaker, we decided upon which SAGCs we would select to repay their debt based on the interest rate that the debt was attracting or whether or not the payment would actually be of any significance to the debt balance held by that particular SAGC. Therefore, Madam Speaker, wherever possible, the government will seek to accelerate reduction of the entire public sector debt position. With those few words, Madam Speaker, I thank you.
Personal explanations.
Recognized honorable member from the District of Easton.
Thank you, Madam Speaker. Madam Speaker, I would like to turn your attention to certain of the comments made by the Honorable Samuel Bulgin, Attorney General and second official member of this legislature, during the second reading of the Legal Practitioners Bill, wherein he opined that the practice of Cayman Islands law overseas was not prohibited in accordance with Section 10 of the Legal Practitioners Law 2015 revision. Madam Speaker, it is recognized that the Honorable Attorney General's position on this matter is his professional opinion and is respected as such. We nevertheless sought our own legal opinion. Madam Speaker, our legal opinion has been proffered by Paul Garlick, QC of the United Kingdom. Madam Speaker, suffice it to say, our opinion differs from the position advanced by the Honorable Attorney General. And in the interest of transparency and fairness, to allow these chambers and the people of this country to have a balanced view of this matter, I wish to read and lay on the table this opposite position.
So ordered.
Madam Speaker, it begins with, in the matter of Section 10 of the Legal Practitioners Law 2015 revision, advice. 1. In this matter, I am asked to advise upon the question of whether, when the partners of a Cayman Islands law firm, persons A and B, employ a person overseas, person C, to provide services as an attorney at law in the Cayman Islands, without person C having been properly admitted to practice.
Recognize honorable Premier.
Madam Speaker, I just wish to check whether or not we have the same document that the member has, because he doesn't appear to be reading precisely what is here. Or is he pre-seeing it?
Member, are you reading from the same document that the chair approved this morning?
Madam Speaker, I just gave the Speaker, the Sergeant, the document. I don't know how the AG, he got it.
Can you just check the chair's copy to make sure it's the same thing as yours, please?
Which lines did I miss?
Member from Easton, if it's the same document, I would advise that you start back from the beginning.
Madam Speaker, as far as I know, I gave you the same document. I would like to know how the government got a different document.
Because member, as you stood up, in anticipation of you laying it on the table, I asked the Sarge if he could make copies of it so that members could have copies and the House would not have to wait for copies of it. It is a legal document, and in the fairness and the balance, the Attorney General proffered a legal document rather than have the House adjourn and go back while you were standing up getting ready to lay it. The Sarge then started to distribute it. If you did not want it to distribute at stage, I take full responsibility and apologize, but that's the time they got it, as you were standing up and getting ready to say so.
Madam Speaker, I'm even more confused now.
Honorable Premier.
Madam Speaker, the member from East End said in his opening that he was going to read from the advice of a Queen's Counsel, Paul Garlick QC. Is there more than one advice?
Madam Speaker,
There's only one.
maybe the one that you received was the draft one. So maybe it is my fault, Madam Speaker.
That's the one I approved.
It is basically the same as just the other one has a signature on it.
This
I
one
was
this one
reading-
has the signature.
I was reading from the draft, Madam Speaker. I do apologize for that.
Okay,
Yeah, I will start over with the main one.
please do.
For once, the Premier was right. So, Madam Speaker, let me begin. In the matter of Section 10 of the Legal Practitioners Law 2015 revision, advice. In this matter, I am asked to advise upon the question of whether, if the partners of a Cayman Islands law firm, persons A and B, employ a person who is overseas, person C, and who has not been properly admitted to practice as an attorney at law in compliance with Section 3 of the Legal Practitioners Law 2015 revision, the LPL 2015. To provide services as an attorney at law in the Cayman Islands, then person A and B commit a criminal offense, either as a substantive criminal offense under Section 10 of the LPL 2015 or a conspiracy to commit such a criminal offense. Background. 2. I have been referred to the following documents attached to my instructions. A letter addressed to the Honorable Chief Justice Anthony Smelly dated the 17th of February 2017. B, a letter from the Honorable Chief Justice Anthony Smelly dated the 21st of February 2017. C, a statement dated the 16th of January 2013 made by Mr. Ian Paget Brown, the chair of the Law Reform Commission. All those documents, Madam Speaker, has been laid in this honorable House. 3, the above-mentioned documents have given me an insight into the problem that currently exists within the legal profession in the Cayman Islands. At the root of this problem are the acts of some, not all, Caymanian law firms to circumvent the provisions of Section 10 and 12 of the LPL 2015 by holding out lawyers from or practicing in foreign jurisdiction as lawyers who are qualified to advise upon matters regulated by Caymanian law. The relevant laws of the Cayman Islands. 4, I have referred to the following provisions of Caymanian law. A, the Legal Practitioners Law, the LPL 2015. B, the Penal Code 2013 revision. 5, in addition, I have helpfully been referred to the following reported cases. A, some Chache Leon Prasert versus 1, the government of the United States of America, and 2, the Liachi Kao Reception Center, Hong Kong, 1990, UKP 31, 2nd of July, 1990. B, R versus Smith, Wallace Duncan, number 4, 2004, 2 CR APP R 17, 2004, EWCA CRIM 631. C, R versus Simon Guy Shepard and Stephen Whittle, 2010, EWCA CRIM 65. D, Regina versus Rogers, Bradley, and others, 2014, EWCA CRIM 1680. The above-mentioned authorities have given me a very good insight into the current common law rules regarding jurisdiction in a case in which there is an overseas element. However, for reasons that are mentioned in paragraph 16 below, I have not had to rely upon the common law for jurisdiction to be found in this case. Regulation of the legal profession in the Cayman Islands. 7, regulation of the legal profession in the Cayman Islands is achieved by a combination of legal provisions dealing with A, the admission of barristers, solicitors, and others to practice as attorneys at law, and B, the requirement that all persons practicing as attorneys at law must be in possession of a current annual practicing certificate. Whilst these two systems of regulation are complementary, I am of the opinion that they stand separately from each other, dealing with two separate aspects of regulation of the legal profession. The first regulates those persons who are entitled to be admitted to practice as an attorney at law. The second deals with the continuing supervision of those who have admitted to practice. Admission is dealt with by the provisions of Section 3 of the LPL 2015. The requirement to hold a current practicing certificate is dealt with by Section 12. I shall set out the requirements under Section 3 and 12 separately below. 8. Those instructing me have expressed the opinion that the provisions for admission to practice and the requirement to hold a practicing certificate are cumulative and interdependent. Whilst I agree with the proposition that they are complementary, it is clear from the structure of the legislation and also from the separate sanctions provided for by Section 10, a criminal offense punishable with a fine, and Section 12(3), an order suspending an attorney at law from practicing, that they are distinct from each other. Admission to practice as an attorney at law. Section 3.1 of the LPL 2015 deals with the qualifications required for admission as follows. 3.1. Subject to this law, a judge may admit to practice as an attorney at law in the islands any person who, A1, is entitled to practice at the bar of England and Wales or the bar of Northern Ireland, and 2, having received a certificate of call from either of those bars, has either A, serve 12 months pupillage in England, Wales, or Northern Ireland, or B, serve the term of articles in the Cayman Islands required by Schedule 3 of the Legal Practitioner Student Regulations 2015 revision. 3, is a member of the Faculty of Advocates of Scotland or a solicitor of the Supreme Court of Judicature of England, Scotland, or Northern Ireland. 4, is an attorney at law of the Supreme Court of Jamaica. Or 5, is a writer to the Signet of Scotland or a solicitor admitted to practice in Scotland. Or B, satisfies a judge that he is entitled to practice in any court of any of the Commonwealth and possesses a qualification comparable as to the standard law, practice, and procedure with those specified in paragraph A or C, is qualified to practice as an attorney at law under regulation made under Section 20. Section 3.2, Section 3.2 of the LPL 2015 deals with the procedures for applying for admission as follows. 3.2, a person who is qualified under subsection 1 may apply for admission to practice as an attorney at law, and such application shall be made in writing addressed to a judge and be filed in the office of the clerk of court, together with A, the certificate of the applicant's call to the bar, or, as the case may be, of his admission to the Faculty of Advocates, or of his admission as solicitor, writer to the signet of or law agent aforesaid agent aforesaid, or the correspondence certificate relating to any qualification referred to in paragraph B or C or subsection 1. And B, an affidavit signed by him in the presence of the clerk of court, who shall subscribe his name as a witness thereto, verifying that the certificate is a true certificate and that the applicant is the person named therein, and that he is qualified as prescribed by subsection 1, hereinafter referred to as the prescribed qualification. Provided that a judge may exempt any such person from producing the said certificate and from verifying the same if he is otherwise satisfied that the applicant possesses the prescribed qualification. 11. I note that those instructing me have informed me that in order to be generally admitted, which I take to be a reference to admission under Section 3.1, rather than limited admission under Section 4, the process requires that the applicant, who is not a Cayman status holder, shall provide evidence of a work permit attached to the affidavit filed in support of the application. I have been informed that without such evidence, an application for admission by a non-Caymanian must fail. B, Madam Speaker, I'm sorry. However, I am unable to see any statutory basis for the proposition that there is a requirement to exhibit such a work permit. It may be the case that the court, under its inherent jurisdiction, has developed this practice, but it does not seem to be a statutory requirement. In any event, the only relevance to the problem in issue in this case is that there may have been some illusion between the requirement for admission under Section 3.1 and the requirement under Section 12.2 for those who do not have Caymanian status to produce a current and valid work permit. However, certainly that would fall under the immigration law. However, any such illusion does not mean that the requirement for a work permit is relevant to the question of whether an offense may have been committed under Section 10 of the LPL 2015. I shall deal with this question in more detail below. However, as stated above, I do not think that this issue affects in any way my opinion in relation to the core matter that I am asked to advise upon, which I have set out in paragraph 1 of this advice. The criminal offense under Section 10 LPL 2015. 12. The wording of Section 10 is crucial to the question in issue in this matter. Section 10.1 provides as follows. 10.1. Subject to Section 4, a person who, not being admitted to practice and enroll as an attorney at law or otherwise lawfully authorized, shall either directly or indirectly, for or in expectation of any fee, gain, or reward, draw or prepare any instrument relating to movable or immovable property or any legal proceeding, or shall receive any fee, gain, or reward for drawing or preparing any such instrument or proceeding, commits an offense and is liable on summary conviction to a fine of $200. Subsection 2 and 3 are also relevant. 2. Subsection 1 shall not extend to any public officer drawing or preparing instrument in the course of his duty, or B, any person employed merely to engross or copy an instrument or proceeding. 3, in this section, instrument does not include an agreement under hand only, B, a letter of power of attorney, or C, a transfer of stock containing no trust or limitation thereof. 13, it is therefore clear that Section 10.1 of the LPL 2015 creates a substantive criminal offense. The actus reus of the offense, that is the conduct element of the offense, is committed if the following conduct occurs. A person who is not admitted to practice and is not enrolled as an attorney at law, either B, directly or indirectly, C, for or in expectation of any fee, gain, or reward, D, draws or prepares any instrument relating to movable or immovable property or any legal proceeding, E, or receives any fee, gain, or reward for drawing or preparing any such instrument or proceeding. It is important to note, 14, it is important to note that the word instrument is given a restrictive meaning by Section 10.3 of the LPL 2015. By Section 10.3, instrument does not include an agreement on the hand only. B, a letter of power of attorney. C, a transfer of stock containing no trust or limitation thereof. 15, it is clear that the conduct element of the offense under Section 10.1 must be committed by a person who is not admitted to practice and is not enrolled as an attorney at law. In my opinion, these words relate to not being admitted to practice under Section 3 and to not being enrolled under Section 5 of the LPL 2015. The offense is not committed where a person is admitted under Section 3 and is enrolled under Section 5, but does not have an annual practicing certificate required under Section 12. I am fortified in this opinion because the sanction for practicing or attempting to practice without being in possession of a current annual practicing certificate is suspension under Section 7.1 This is a regulatory or disciplinary offense and is not a criminal offense. For convenience, I have set out the terms of Section 12.3 and the LPL 2015 below. Practicing or attempting to practice as an attorney at law without an annual practicing certificate. Section 16, Section 12.3 of the LPL 2015 provides as follows. 2, 3, a person who, not being a person practicing by virtue of Section 4, practices or attempts to practice as an attorney at law without being in possession of a current annual practicing certificate issued under subsection 2 is liable to suspension under Section 7.1. Conspiracy under the provisions of Cayman law. 17. The provisions of Cayman law dealing with conspiracies are contained in Section 321 and 322 of the Penal Code. It is necessary and convenient for me to set them out in full. 321. A person who conspires with another or others to commit an offense or to do any act in any part of the world which, if done in the islands, would be an offense punishable with imprisonment, and which is an offense in the place where it proposes to be done, commits an offense and is liable, if no other punishment is provided, to punish imprisonment for 10 years, or if the greatest punishment to which a person convicted of the offense in question is liable is less than imprisonment for 10 years, then to imprisonment for such lesser term. Other conspiracies. 322. A person who conspires with another or others to A, prevent or defeat the execution or enforcement of any law or regulation. B, causes any injury to the person or reputation of any person, or to depreciate the value of any property of any person. C, prevent or obstruct the free and lawful disposition of any property by the owner thereof for its fair value. D, injure any person in his trade or profession. E, prevent or obstruct by means of any act or acts which, if done by any individual person, would constitute an offense on his part, the free and lawful exercise by any person of his trade, profession, or occupation. F, effect any unlawful purpose, or G, effect any lawful purpose by any unlawful means, commits an offense. Conclusions. 18. In my opinion, an agreement between two or more persons to carry out conduct which contravenes Section 10 of the LPL 2015 is clearly a criminal offense. However, the conduct which amounts to an offense under Section 10 is very limited, as I have explained above. This is so whether the agreement to carry out the conduct is committed partly within and partly beyond the jurisdiction of the court. This is the case by reason of Section 4 of the Penal Code, which provides as follows. 4. When an act, if done wholly within the jurisdiction of the court, would be an offense against this law, is done partly within and partly beyond the jurisdiction. Every person who, within the jurisdiction, does or takes any part in such act may be tried and punished under this law in the same manner as if such act had been done wholly within this jurisdiction. 19. It is a criminal conspiracy where two or more persons agree to prevent or defeat the execution or enforcement of any law or regulation. This is the case by reason of Section 322A of the Penal Code, which I have set out above. By Section 3 of the Penal Code, law includes any order, rule, or regulation made under the authority of any law. In my opinion, the provisions of Section 12.3 of the Legal Practitioners Law 2015 come within the definition of a law or regulation, and therefore an agreement between two or more persons to prevent or defeat the execution or enforcement of the provisions Section 12.3 amounts to a criminal offense under Section 322 of the Penal Code. In my opinion, the conduct set out in paragraph 1 of my advice necessarily involves preventing or defeating the execution or enforcement of Section 12.3 and therefore amounts to a criminal conspiracy. Again, by reason of Section 4 of the Penal Code, this is so, whether the agreement to carry out the conduct is committed partly within and partly beyond the jurisdiction of the court. 20. Finally, it should be noted that the conduct which would amount to a violation of Section 12.3 of the LPL 2015 is much wider in scope than the conduct required to amount to the offense under Section 10. The prescribed conduct under Section 12.3 extends to any conduct which amounts to practicing or attempting to practice as an attorney at law without being in possession of a current annual practicing certificate. Accordingly, a conspiracy to prevent or defeat the execution of enforcement Section 12.3 extends to all activities amounting to practicing or attempting to practice as an attorney at law. 21. Should those instructing me wish to expand upon any of the matters that I have set out above, I would be pleased to do so, either in writing or during a telephone conference. Signed by Paul Garlick, QC, 2 Plowden Building, Temple, London, EC 4Y9BU, the 23rd of March, 2017. Madam Speaker, may it please you.
Madam Clerk, I recognize the Honourable Attorney General.
Thank you, Madam Speaker. Just to say thanks to the honourable member from East End for his opinion.
Madam Speaker,
Honourable Attorney General.
Madam Speaker, on a procedural matter, no.
Order. Can we have both members please seated? Under Standing Order 31, after a personal statement is given, no debate can arise thereon, so unless it's a point of order, I cannot entertain in a debate. Honourable Attorney General, can you please state your point of order?
Thank you, Madam Speaker. I thought it was a point of elucidation, but I'll bow to your ruling. Suffice it to say that I stand by my earlier position on the matter.
Madam Clerk.
Obituary and other ceremonial speeches.
None.
Raising a matter of privileges.
None.
Government business. Bills. Committee and bills.
The House will now return to committee to continue the consideration of bills. Please be seated. Committees resumed. I recognize the Honourable Minister for Planning with the continuation of the Water Authority Amendment Bill 2017.
Thank you. Madam Chair, before I start this, and I will in 2 seconds, I just want to seek some guidance from you. Madam Chair, the bill for a law to provide for the regulation of the water sector by the Utility Regulation and Competition Office and for incidental and connected purposes. We have completed the committee stage, or I thought we had completed the committee stage amendments for that bill. Madam Speaker, Madam Chair, forgive me, what I need to accomplish with the help of yourself and the good committee is I have additional committee stage amendments to that bill. Unfortunately, how they are crafted in the amendments, they are intertwined with the original amendments that I have done. So I need to, with your permission, recommit the bill itself and read the new committee stage amendments, which will supersede the original committee stage amendments. And after sitting with the legal draft person for quite some time, we have concluded that that is the only sure way to not have any mix-up in the amendments. So we need to pull back what we've done and do the entire new set of amendments over. And I'm just advising you that, not to say that I want to do that first. I'm just advising and making sure that you don't have a problem with that. And at the same time, with all the amendments that I'm doing, I trust that they have been circulated to members so that members have copies.
Honourable Minister, the chair would propose the following way forward, that we complete the Water Authorities Amendment Bill, which was partly completed.
Right.
On the conclusion of that, I see you have 3 bills remaining. We would proceed with those 3 bills, dispose of them, and then before we move on to item number 5, the LP Bill 2016, you would recommit the water sector's bill.
Okay. That's fine. That's fine.
Can I also get some direction from members? It's now after 1, but because we had the late start, perhaps if I could ask my very capable and competent deputy to ensure that he has lunch while we're in here, unless you need to vote or contribute to it. And then we would switch. I'll have lunch and continue on, so members can go in and out to have lunch at the same time. Could I have some indication from members? Okay. All right, Honourable Minister.
Thank you. Madam Chair,
Madam Clerk will read the bill.
The Water Authority Amendment Bill 2017.
Madam Chair, just want to ensure where we were when we broke with the Water Authority Amendment Bill. I had read in clause 7 by deleting paragraph B and substituting the following paragraphs. I'm not so sure whether we had taken the vote on the amendments to clause 7. So out of an abundance of caution, I want to complete the original amendments, then I will go back and ask to recommit sections 2 and 5.
Please proceed accordingly, Honourable Minister.
Thank you. Madam Chair, under the relevant standing order, I move to amend in clause 7 by deleting paragraph B and substituting the following paragraphs. B, yes, sir. By repealing paragraph J and substituting the following paragraph. J, prescribing charges and fees or the criteria for calculating charges and fees to be paid by service providers to the authority in respect of the various statutory functions exercised by the authority under this law. And C, by repealing paragraphs K, L, M, and N. And, Madam Chair, if I may just speak quickly to it.
The amendment has been duly moved. Does the Honourable Minister wish to speak to the amendment?
I'm sorry for anticipating you. Forgive me. Yes, Madam Chair, just for a minute, because the member from East End, when we were discussing this issue yesterday, was following up on the amendment that I'm proposing now, and I just want to advise that that amendment is simply to ensure that the Water Authority has the ability to charge fees for its statutory work that it does on a daily basis, such as water testing facilities when asked. I think they also do for quarry. What I'm reading now is what I'm reading right now is what we were discussing yesterday, the old one. So I just wanted to clarify because the member had asked. It was seeming like this one also had to do with the Water Authority actually still regulating. And I'm saying to the member that the reason for this amendment is to allow them to set prices for the other work that they do, not regulatory work. Their statutory obligations, as I said, such as water testing, and whenever there are mining licenses in order to calculate volumes and such the like when quarrying is done, the Water Authority has certain responsibilities in that area, and it's just a matter of them being able to charge fees. That's all that amendment is doing. Their own work.
Through you, Madam Chair.
Honourable Member from Northside.
Fitted Water Authority's own work, but not as part of a regulatory function that another water company may
Exactly.
need water testing.
Exactly.
That would not be tested by the
No.
Water Authority.
No.
Okay.
Recognize
Exactly.
the Honourable Member from East End.
Well, thank you, Madam Chair. Madam Chair, may I suggest to the Minister that we make that as unambiguous as possible. Because I can see someone or ones in the water company saying, we have authority to do that.
Water company or Water Authority? I wasn't sure which one. you
Water
meant.
Authority. Water
Yeah.
Authority. Sorry.
Yeah.
Because that's what we're talking about.
Yeah, but you said companies.
Oh, I'm sorry. I'm sorry.
Yeah.
I can see the wording of that being misconstrued and a confrontation between the office and the Water Authority and the Water Authority and others who were controlled by the office. And that's
Control
or
or
regulated.
regulated by? Okay.
Regulated. Pardon
Okay.
me. I know the water authority is represented on the quarries committee. Committee, I
Yeah.
think it's called.
Yes.
Yeah.
I can't remember the name myself.
Yeah.
The
Mine and
something.
it
And
escapes
they are the
me.
ones, and they are the ones responsible for doing, like, making sure the volumes are correct and the royalties that are paid are correct and that type of stuff.
But only on advice to the office. Should only be on advice. Like how cabinet requires the DOE to give advice on advice on the Queen's Bottom and that kind of thing that cabinet has to make a decision on. I think it needs to be similar to that, where they go and do the assessment and on request, upon request from cabinet, and then they provide their professional advice. Because if we
So I'm not being funny through you, Madam Chair.
Honourable
Do
Minister.
you have any specific suggestion? Or can we approve this in principle and, hearing what you're saying, ask the technical people if they would look at it? I'm trying to move forward is all I'm saying.
yeah, so am I. But or we carve out what they can charge for their services. But if we don't make it clear, I can see the lines being blurred.
See, forgive me
Honourable
where
Minister.
we are separate. And all I'm saying to you is that I hear what you're saying, but I don't see it as being unclear. So I'm trying to put my finger on where the question of clarity is in the proposed amendment. That's what I'm trying to determine.
Member from Easton.
Madam Chair, I think we were.
Let me ask a member this, if you don't mind.
Honourable Minister for Planning.
Perhaps if I went through these amendments, because this one is nearly finished, and also the additional amendments, I don't know whether that would help in any way.
Well,
Because
I haven't had the chance to take a look at
and I was going to go through them because it's not a whole pile. The new ones are the whole pile, but they take away some of the questions you were asking prior to this one yesterday, and I don't know whether that would help to clarify.
Member from Easton.
Madam Chair, I don't have like how they do on them computer screen, you put them up together and get two screens and do it. Despite having two
You got
eyes.
a black line copy?
Yeah. I can't, in all fairness, say that I can see the difference at this stage since it was only just distributed. Madam Chair, I don't know if I've explained myself properly to the minister.
My view is that you have.
Okay.
The only difference is what you see as unclear, I don't see it as unclear. That's all I'm saying to you.
Well, what I am seeing is blurred lines and the overlapping responsibility. Now overlapping. The responsibility that the office has to regulate, and that being overlapped by the water authority and blurring those lines. That's basically where I'm at.
So if
Honourable
this
Minister for
might help,
Infrastructure.
in the original amending bill
Uh-huh.
that we're trying to amend now, if you look at
The bill?
clause 5B,
You know I'll find it. But the Water Authority.
clause 5B, Madam Chair, and if
Page 7.
and what I want to read is what that amendment will make the section read in the substantive law. So what the law what the amendment says is that in subsection 4, by inserting after the word appropriate the words, but rates and charges for the provision of water supply and wastewater services shall not be fixed or imposed without the prior written approval of the office. So the section, is that what you were?
That's the crook.
Member
of-
from Easton.
That's the crux of the matter.
So therefore, the new section in the law, once this amendment is approved, will read, the authority may exercise its powers to fix charges by reference to such matters and may adopt such methods and principles for the calculation and imposition of the charges as appear to the authority to be appropriate, but rates and charges for the provision of water supply and wastewater services shall not be fixed or imposed without the prior written approval of the office. I don't know if that helps in any way.
Member from Easton.
Madam Chair and my good friend, the Minister, where's the law?
What I just read to you is what the law will say now after the amendment.
Okay. All right. They're allowed to fix it. And fix those rates. And must get the approval of the office prior to implementation of those rates. Understand that. Therein lies, and the drafters are sitting right behind you. And this is based on experiences, and you know that. Where I am at is that there remains the possibility of, if they are the only authority on fixing those rates, they're the only expertise that is available, then we have a problem between those lines of regulator and setting rates.
Yeah, but those rates are only rates that they charge, not what anybody else is charged. It's only rates for things services that they perform. That's what this section is about. It's nothing about telling somebody else what they can charge. That's not what this is about.
Member from Easton.
I understand, but
that's where I'm having a problem understanding the blurred lines.
Well, they are a sector provider, be that water rates or in their sector.
Or
and
water
and
testing or whatever.
Right, and that office has an absolute responsibility to protect those people, so it is their responsibility to have the expertise available to ensure that those rates are correct or reasonable in maintaining a viable water authority, but at the same time protecting the the consumers in that sector.
Right, yeah, right.
I don't see all, anyway, I guess that would be operational, and they would put their expertise inside there in the office as a regulator, because that's how regulatory commission regulators work, because there are so many moving parts and so many different applications. It's unlike a regulatory body which is responsible for health, and it's one thing.
Yes, I
These are
understand.
different ones,
Exactly.
which have different applications.
Right.
But that authority needs to have the available to it. That board needs to have available to it expertise they can trust, and that should not be in one of the people that they one of this sectoral provider
So
that
you're-
they
So you're taking the regulatory functions, which is what we're doing now, amending the Water Authority bill to correct that law and taking away the regulatory functions. This amendment simply is retaining the authority by the Water Authority to be able to prescribe fees for services that are part of their statutory realm. They're not telling the office that these charges are what other people can charge. This is just all confined to them. Yeah, I just want to make sure. You see, I'm trying, if
Okay.
possible, to put it to bed. Madam Chair, I believe I understand what the member from East End is saying. All I'm saying, why I don't think it's blurred, is because this whole section is internal to the Water Authority. It does not include anybody else that the Water Authority can say, this is what anybody else has to charge. That's not what this is doing.
I
Okay.
think if I understand what the member from Eastern is trying to proffer, is that because the Water Authority, because in his opinion, the Water Authority is setting rate for X percentage of the community, and they're also regulating that rate. Where's the separation between the protection of that sector and the setting of the rate? Is that correct, member from Eastern?
yes, Madam Chair.
So that's what they do on their own. But where the office comes into the whole play is where the section says, but rates and charges for the provision of water supply and wastewater services, which is what they will be regulating. The Water Authority cannot fix them without the office approving them. So it's, I honestly don't know what else to say.
Well,
Member from Eastern, if you could.
yeah, Madam Chair, and I guess we've been going at this too long, and I do apologize. Madam Chair, there is no provision here that says how they need to justify those to the office, i.e. the regulatory body. We need to ensure that the office has a Ronald Reagan inside it. Trust but verify. There needs to be certain provisions in place to ensure that office has available to it the justification for having set those rates. Madam Chair, you have been through that yourself. And in the absence of that, the office is between a rock and a hard place. And then that's where the lines are going to blur.
All right, I'll have a final submission in the way of reply from the Honorable Minister, then we'll move on.
Madam Chair, I don't want to leave it hanging. And I do understand what the member is saying, but I am advised by those who have crafted all of these pieces of legislation that the water sector, the bill for the regulation of the water sector includes all of the caveats that need to be there to ensure that the fears that are expressed, which are justifiable when you look at this on its own, are made unfounded, because that bill clarifies what can and cannot happen and where the lines are, so that they're not as blurred. So, we need to take the vote.
I was just scanning for the quorum position. I wasn't actually waiting for a reply. I put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. The amendment stand part of the clause. I'll now put the question that clause 7 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 7 as amended now stand part of the bill.
Clause 8, amendment of miscellaneous sections, substitution of the word cabinet for the word governor.
Honourable Minister, there's a proposed amendment to clause 8.
Yes, Madam Chair. Madam Chair, I would wish to propose under the relevant standing order by inserting after clause 8 the following clause. The marginal note to read, amendment of miscellaneous sections, substitution of the word wastewater for the words sewage and sewerage. 8A, the principal law is amended by deleting the words sewage and sewerage wherever they appear and substituting the word wastewater.
The amendment has been moved. As Honourable Minister, any other member wishes to speak to it? If not, I put the question that amendments stand part of the clause. Sorry, member from Easton. Okay. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendments stand part of the clause. I now put the question that clause 8 as amended stand part of the bill. All those in favor, please say aye. Against, no. I believe the ayes have it. Clause 8 as amended now stand part of the bill.
Clause 9, transitional provisions.
Honourable Minister, there's a proposed amendment, clause 9.
Madam Chair, I move that in clause 9, subclause 6 be deleted.
If there's no debate, I put the question that amendments stand part of the clause. All those in favor, please say aye. Against, no. The ayes have it. The amendments stand part of the clause. I now put the question that clause 9 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 9 as amended stand part of the bill. I know we're getting into that season, but I'm hearing a rhythm that is unparliamentary, so if the rhythm could be decreased. Honourable Minister responsible for infrastructure, I believe you need to recommit 2 clauses.
Yes, Madam. Madam Chair, I would wish to recommit clauses 2 and 5 with your permission in order to make some additional, in order to propose some additional committee stage amendments to the Water Authority Amendment Bill 2017.
The question is that clauses 2 and 5 be recommitted. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The will of the House is for the clauses to be recommitted. Honorable Minister, please proceed.
Thank you, Madam Chair.
Then Madam Clerk will read and then you will proceed.
Clause 2, amendment of section 2, definitions and interpretation.
Honorable Minister.
Thank you, Madam Chair. Madam Chair, understanding Order 52, 1 and 2, I wish to make the following amendments to the Water Authority Amendment Bill 2017. That the bill be amended in Clause 2 by deleting paragraphs C, D, and E and substituting the following paragraphs. C, by deleting the definitions of the words consumer, governor, and rate cap and adjustment mechanism. D, by deleting the definition of the word license and substituting the following definition. License means a permit or other enabling instrument issued by the authority under this law. E, by deleting the definition of the word wastewater and substituting the following definition. Wastewater means any waste substance, liquid or solid, associated with human habitation or which contains or may be contaminated with human or animal excrete or offal. OFFAL, Madam Chair, or trade effluent or both from residences, commercial buildings, industrial plants and institutions, together with any groundwater surface runoff or leachate that may be present. F, by deleting the definition of the words water resources and substituting the following definition. Water resources means canals, groundwater, groundwater lenses, ponds, territorial waters, and underground water. And G, by deleting the definition of the word works and substituting the following definition. Works includes wells, desalination plants, pumping installations, pipelines, reservoirs, tanks, ponds, valves, buildings, machinery, metering devices, and other apparatus constructed for or used in connection with the abstraction or storage of groundwater, the conveyance of water or wastewater, the processing of water, the treatment of water, the use of groundwater for any purpose, or the introduction of fluids directly into groundwater, whether by means of a well or pipe or otherwise.
The amendment has been duly moved. Does any member wish to speak to the amendment? The honorable member from East End.
Madam Chair, just to find out, I'm wondering did we amend that yesterday? So we're not amending the bill, we're amending the bill as it was amended. Let's make sure we do that because we gotta get ourselves involved in some.
That's exactly why we're doing it the way we're doing it, to accomplish exactly what you're saying.
No, but understood. But what I'm saying is when
Understood.
we may get that mixed up somehow with that vellum being sent up because the bill was already amended and we have recommitted that amended bill.
And we completely agree with your observations, but just so that the member will know, I was studiously given the lesson by the Honorable Speaker, who is now Chairman, to make sure that nothing like that happened.
Yeah, we'll get another instruction.
No. No, we remembered that too.
The chair is not in the habit of giving more than one instructions that are contradictory. I know where you're
now
coming from, but
now-
for the record, I just wanted to put that on
Not
the
you,
record.
Madam Speaker, I
Fine.
would never, I know where your position is there.
Thanks for your expressions of confidence. Can I now put the vote?
Oh, I have plenty of confidence in you.
If there's no further
Aye.
debate, I put the question that clause 2 as amended is now being amended and they will now stand part of the clause. All those in favor of the amendment to the amendment, say aye.
Aye.
Those against, no. I believe the ayes have it. The amended clause 2 as amended is now amended by the new clause 2.
Thank
Sorry
you.
for the verbiage, but I just wanted to be absolutely clear.
Perfectly right. Thank you.
I will now put the question that the amended clause 2 has been amended by the new clause 2 and it does stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The new clause, the original clause 2 as amended is now being superseded by the new clause 2 and it now stands part of the bill.
Clause 5, amendment of section 7, powers of authority in regard to water supply and sewage.
Honorable Minister, there's a proposed amendment to the recommitted clause 5.
Yes, Madam Chair, and Clause 5 is in exactly the same shoes as Clause 2. So, I would move that Clause 5C and D be deleted and substituted by the following paragraphs. C, by repealing subsections 5, 6, 9, and 10. And D, by repealing subsection 7 and substituting the following subsection. 7, the authority shall establish minimum environmental standards for the protection of the environment generally, including standards for the limitation of discharge into the atmosphere, water, or land, and provisions for compliance with these standards shall be included as license obligations in licenses or administrative determinations issued by the office under the water sector regulation law or any other law in force in relation to water or wastewater.
The amendment has been duly moved. Does any member wish to speak? If no member wishes to speak, I put the question that the amended clause 5 be further amended and stand part of the clause. All those in favor, please say aye. Aye. Against, no. The ayes have it. Clause 2, as was previously amended, is now superseded by the new amendment and stand part of the clause. I will now put the question that the original amended clause 2 has now been amended by the new amendment for clause 2 and it does stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it. The original clause 2 has been amended by the new clause 5 has been amended by the new clause 5 and it now stands part of the bill.
A bill for a law to amend the Water Authority Law 2011 revision as a consequence of the establishment of the Utility Regulation and Competition Office to transfer the Water Authority's economic regulatory responsibilities to the Utility Regulations and Competition Office and for incidental and connected purposes.
The question is that the title does stand part of the bill. All those in favor, please say aye. Aye. Against, no. The ayes have it. The title now stand part of the bill.
Uh-huh. Okay.
The Prescription Amendment Bill 2017, Clause 1, short title.
Put the question at clause 1, stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, amendment of Section 9 of the Prescription Law 1997 revision, procedure for establishing right under Section 4.
I recognize the honourable member from Northside with a proposed amendment.
Madam Chairman, after some long and detailed discussions with the minister, I am prepared to withdraw the amendment.
I take it the discussions were successful.
Absolutely.
The question is that the amendments that as proposed by the member from Northside be herewith withdrawn. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The proposed amendment is not carried.
A bill for a law to amend the Prescription Law 1997 revision to permit a statutory authority, department of government, or agency charged with responsibility for Sorry.
Whatever it is, I take full responsibility, Madam Chair.
Clause 2, amendment of Section 9 of the Prescription Law 1997 revision, procedure for establishing right under Section 4.
I put the question that clause 2 stands part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 2 now stand part of the bill.
A bill for a law to amend the Prescription Law 1997 revision to permit a statutory authority, department of government, or agency charged with responsibility for ensuring access to public beaches to make an application under the law to have a dispute settled regarding access to a public beach and for incidental and connected purposes.
I put the question that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The title now stand part of the bill. Honourable Minister.
Madam Chair. No. I will have opportunity in the next one. Thanks.
The Public Lands Bill 2017, Clause 1, short title and commencement.
I put the question that clause 1 stand part of the bill. All those in favor, please say aye.
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 Against, no. The ayes have it. Clause 1 now stand part of the bill.
Yeah. Public lands.
Honourable Minister responsible for lands. The proposed amendments A and B are general amendments throughout the entire bill, so perhaps you may want to do those two before you go to clause 2.
Not a problem.
Okay, please proceed.
Madam Chair, under the relevant standing order, I move that the bill be amended A, by deleting the words vendor's license wherever they appear and substituting the words vendor's permit. next amendment is in clause 2, Madam Chair, so I best stop there.
The amendment has been moved. Minister, you did both vendors license, permit, and commercial activity. You could have it just that I didn't recall commercial activity.
Where is commercial activity?
B. Member from Northside.
No, we got,
Through you, Madam Chair, was there an early amendment which dealt with the subclause 2 of 1, where there was a replacement of that short thing by several lines about when the law shall come into effect, because I think they added other stuff that sections can come in before the sections.
This is the third version that I'm referring to now. So let me just consult.
But
the one I have is the correct one.
Member,
Sorry?
member from Northside, could you just read the reference that you have so the clerk can follow, please?
I don't have it currently before me, but I remembered a earlier circulation of an amendment to clause 1(2), which added to the definition of, where it says now the law come into force, such date may be appointed by order made in council. They added words to the effect that certain sections of the law may come in at certain times. Wasn't it this law? Because I got it
No.
marked out here in red.
Not this one.
I don't have that. I think that's a different one, member from Northside, because I believe I'm in possession of all of them with this in my hand, but I don't see that reference for this particular law.
Not the public lands one.
I went through it and wrote it all
I
in red.
understand what you just said, but I never seen
Okay.
it.
Oh, that's fine.
Yeah. I never seen that.
Okay, so if the
I understand.
Honorable Minister could proceed then by reading B.
Yes. So, I've read A. B, Madam Chair, that we would also seek to be deleted is by deleting the words trade or business wherever they appear and substituting the words commercial activity.
The amendment has been duly moved. If no member wishes to speak, I put the question that amendment stand part of the clause. All those in favor, please say aye. Aye. Against, no. The ayes have it. The amendment stands part of the clause, and I put the question that the clause as amended do stand part of the bill. All those in favor, please say aye. Aye. Against, no. The ayes have it. The clause as amended now stand part of the bill.
Clause 2, interpretation.
I recognize the member from Northside with his proposed amendment. Clause 2.
Thank you, Madam Chairman. I was proposing to amend the definition of a crown land to insert after islands belonging to the people of the Cayman Islands, just to establish some kind of ownership for us.
The amendment has been duly moved. Does the mover wish to speak further to it?
I wanted to say, Madam Speaker, that the reason is that the clause would then read, Crown land means land in the islands belonging to the people of the Cayman Islands or held in trust for Her Majesty or acquired for the use of the government.
Does any other member wish to speak? Honorable Minister?
Just 1 second, Madam Chair.
Certainly.
Madam Chair, I think that the Honorable Attorney General could offer some advice to this. The principle which is being sought to be applied by the member from Northside is not one which we are counter to, but I think we have some legal difficulties, and so that I don't say the wrong things, I would ask the Attorney General to clarify those legal difficulties. Hopefully the member from Northside will understand.
Recognize the Honorable Attorney General, but based on a smile from the member from Northside, I think he's fully cognizant that we're not independent, so it's vested in Her Majesty's, the government, but Honorable Attorney General.
Thank you, Madam Speaker. My understanding is that the current definition of Crown land is that Crown land in the island belongs to or held in trust for Her Majesty or acquired for the use of the government. Under the Constitution, I'm just trying to get to Section 38. Let me just double check here. Okay.
Perhaps Honorable Attorney General, you could see whether government is described as the people of the Cayman Islands
No.
or the subjects or Her Majesty.
No, it doesn't say so, Madam Speaker. Subject to powers to dispose of Crown land, subject to any law for the time being enforced in the Cayman Islands. The governor or any person duly authorized by him or her in writing under his or her hand, Majesty's name and on Her Majesty's behalf, may make and execute under the public seal grants and disposition of any land or other immovable property within the Cayman Islands that may be lawfully granted for dispose of by Her Majesty. Point there, Madam Speaker, is that if we're going to make such an amendment, this clearly would require some, I would imagine, imprimatur of the UK before we could do that. Certainly, that's my opinion on the matter.
I suspect the member doesn't want to go to that extreme.
Honorable member from Northside.
I'm quite willing. But anyway, Madam Speaker, let's vote on it.
The amendment has been duly moved. I put the question that the amendment which was moved by the member from Northside stand part of the clause. All those in favor, please say aye.
Aye.
Against, no.
No.
I believe the noes have it. Accordingly, the amendment as proposed by the member from Northside is not carried. The Honorable Minister of Infrastructure, I believe you have some amendments as well.
In clause 2, Madam Chair, 1, by inserting in the correct alphabetical order the following definition. Commercial activity means a commercial enterprise, whether carried on year-round, seasonally, or occasionally. 2, by deleting the definition of trade or business. 3, by deleting the definition of vendor's license and substituting the following definition. Vendor's permit means a permit issued under Section 16 to allow a person to carry on a commercial activity that is otherwise lawful on public land. And 4, by deleting the definition of public land and substituting the following definition. Public land means the following lands, whether or not the public has access to them. A, Crown land, whether owned solely by the Crown or jointly by the Crown and another party, and facilities on Crown land. B, land vested in statutory authorities or government companies and facilities on such land. C, the seabed and territorial waters of the islands. And D, wharfs, jetties, ramps, and docks owned by the Crown, but it does not include areas of Crown land designated as protected areas under Section 7 of the National Conservation Law 2013 for so long as the designation is in force. D, I think I should stop.
The amendment has been duly moved. It hasn't been brought to my attention on the mic, but I did hear what was said.
Get somebody.
Madam Speaker, just bring it to your attention, I don't think we have quorum.
You are indeed correct. Can we just
Sorry,
get a
Madam.
quorum so I can put the vote, please?
Madam Chair, sorry.
Madam Chair, if I could ask the minister,
Member from Northside.
is government land, like public open spaces and all that, is that recorded in the land registry as crown land or public land?
Honorable Minister.
Don't think so,
for-
but 1 second. It's not recorded as crown land. Public open space not recorded as crown land. No, or land for public purposes. It's not.
Honorable Minister.
No, Madam Chair. Public open space or land for public purposes is not recorded as crown land. And I can't remember which law it is, but there are certain things which govern public open spaces and land for public purposes, which would make it impossible to be recorded as crown land because of the activities that can take place on those parcels.
Is
Member
there,
from Northside.
is there a methodology from which we can convert crown land to public land, public
Convert-
open spaces?
Why would we want to convert crown land to
On-
public open spaces?
So we own it and not her?
Honorable Minister for Planning.
Madam Chair, I don't know of any mechanism which would allow that. Let me answer in that way.
I'll put the question that clause 2 is amended, stand part of the clause. All those in favor, please say aye. Against, no. The ayes have it. The amendment stand part of the clause. I'll now put the question that clause 2 as amended do stand part of the bill. All those in favor, please say aye. Against, no. I believe the ayes have it. Clause 2 as amended now stand part of the bill.
Clause 3, Minister's responsibility in relation to public lands. Clause 4, establishment of commission.
If no member wish to speak, I put the question that clauses 3 and 4 stand part of the bill. All those in favor, please say aye. Against, no. The ayes have it. Clauses 3 and 4 now stand part of the bill.
Clause 5, Commissioner's mandate.
I recognize the member from Northside for his proposed amendment.
Thank you, Madam Chairman. Madam Chairman, I propose an amendment to clause 5 to insert after the words public interest and before the words and in the following words after consultation.
The amendment has been duly moved. Does the honourable member from Northside wish to speak to this amendment?
Just briefly, Madam Speaker. Madam Speaker, my concern here is that if the Commission is mindful to change the activities that are currently going on this public land. But let me use an example to illustrate. Right now, we don't allow commercial activities on the public beaches in Northside, Cayman Public Beach, and others. If the Commission was minded to allow commercial activities on a place like Cayman Beach, I want to know that there is some provision in the law that says they have to consult with the people in that community before they make the change.
Madam Chair.
Honourable Minister.
Madam Chair, just to say to the member, because I thought we had gone beyond this, but of course, I do appreciate the fact that the member needs to air the concern, which is fine. The intention is for that concern to be in the regulations whereby it instead of just saying after consultation, the regulations will specify that the commission, whenever making any decisions on any matter concerning either one of the 19 constituencies, will have to consult with the elected representatives of that constituency to make sure that the decision that is being contemplated is one which accords with people of that constituency. So, in a very polite way, I'm asking the member to withdraw his proposed amendment.
Honourable Member from Northside, are you accepting the invitation to treat?
Yes, Madam Speaker, I'll withdraw the amendment.
And I give the commitment.
Yeah, no, and that's good enough for me. That'll be in the regulation.
Thank you.
The question is that the amendment to clause 5 is proposed from the member from Northside be herewith withdrawn. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. The proposed amendment from the member from Northside is not carried. I recognize the Honourable Minister, who also has a proposed amendment to clause 5.
Thank you, Madam Chair. In clause 5, we propose to delete the words "and licenses."
The amendment has been duly moved. Does any member wish to speak? If not, I'll put the question that amendment stand part of the clause. All those in favour, please say aye. Against, no. The ayes have it. The amendment stand part of the clause. I now put the question that clause 5 is amended stand part of the bill. All those in favour, please say aye.
Aye.
Against, no. The ayes have it. Clause 5 is amended, now stand part of the bill.
Clause 6, membership of the commission.
Honourable Member from Northside, you have a proposed amendment, clause 60.
Yes, Madam Chairman, I'm proposing to amend clause 6 by an amendment to clause 6D, which would add would read 6 other members appointed by cabinet, 1 member being from each geographical district.
The amendment has been duly moved. Does the mover wish to speak further to the amendment?
Yeah, I have 2 concerns, Madam Speaker. One, that in the first concern has been slightly reduced by the fact that the commission will have to consult with the representative from each electoral district in that area.
That's right.
But my second concern is that we just passed a bill to the committee stage overarching public authorities, which mandates that no board should have more than 40% official members. And the current structure of this, with the Director of Lands, or designate the Director of Commerce and Investment, or designate the Director of Tourism, as they're amending it, and 2 other members, completely reverses that legal obligation, in that you don't have 60% official and 40% public.
I recognize the Honourable Minister.
1 second to just confer with
Certainly.
technical staff. Thanks. Yeah, but if that's the case, how many more do we have to add? How many in total? So for it to be 4 needs to be 40%.
Member from Northside, while the Honourable Minister is consulting with his technical staff, you did skirt around an issue of electoral districts and did not plunge into the new reform of constituency. Was that your intent?
No, ma'am. I know the legislation. My apologies. I meant electoral districts instead of constituencies, because there's no legal electoral constituencies. Thank you very much for the correction.
No, I wouldn't put it 40%. 1% of 10% of 7.7, 40% is 2.8. You're right. Madam Chair, to calculate this, we're getting into percentages of people, 2.8 people and 3.1 persons and that kind of stuff. But understanding what the member has said, I think the simplest way to do it, because although the member is asking for that, I certainly don't want the committee to have too many persons.
No.
And that is not for any specific reason, but we just know how larger numbers are cumbersome to deal with. So what we're going to suggest is that we, instead of having 2 other persons, we'll have 4 other persons, which will make the constitution of the committee 7, which will then bring the official members in line with being 40%. The reason why I hesitate about from each geographical district is because of the 19 constituencies, makes it a bit difficult. And I'm just trying to think of, in the future, having to choose people and getting into problems with who is in agreement with this, that, or the other. So I think we've conquered the problem of participation by way of calling for elected representatives to be consulted. But the other one, I think we'll just have to add the numbers. But just 1 second, please. Is it regulations that decide those numbers, or that's in the law? Where?
Mr. Minister,
Honourable member from Northside.
can I make a recommendation that you delete B and C and keep the committee at 3? Because they don't need to be on it.
Delete B and C?
Yeah, they don't need to be on it. Certainly, I can't see the role of C. If you delete C and add you,
TAB you're talking about?
yeah, they don't need
Which
to be on
one
it.
is C?
C in my bill says the chief officer of tourism or his or her designate. And I think you propose an amendment to that to make it the chairman of the tourism attraction board.
So Mr. Miller, are you purporting that the entire membership be 3 members?
But no, to get back to his, if he put 4, right, and he take that one out, then he's okay.
No,
Yeah.
I'm just
So
trying
it
to.
would be 6 total.
Okay, I just wanted to make sure we didn't have a 1-1 situation.
No.
Madam Chair,
Honourable Minister.
technical staff are much more comfortable with the idea of just adding 2 more and having 7. So I would ask the member from Northside to let them have their way for today,
But
if
you
you
still
don't
not
mind.
right, but
That's fine. I gotta live with them every day, you see.
3 out of 7 is a little bit more than 40, but 42%, something like that. I don't know. Okay.
So that's why I was coming down. I was rounding it off.
Okay.
Unless you would prefer me to add another body. I'm not averse to that.
Yeah, I would add.
Would you
another
like
body.
would you like us to say add 3 more to make it 8?
Because then you're in full compliance with the public authorities bill.
Then we know how to deal with parts of the body,
Yeah.
or whether it's a whole
Right.
person or not. So-
Honourable
so-
Minister, don't mean to interrupt your thought, but seeing that the Honourable Deputy Premier is otherwise urgently engaged, I'm sure that he would not mind the chair speaking on his behalf to
We've
ensure
already considered that.
at
One of them
least
will
one
be.
of them be from the sister
Yes, ma'am.
islands.
We've already considered
I know I
that.
wouldn't have to work hard to convince you with
Yeah.
that. You're always
We've already
thinking of them.
considered that. So even Madam Chair, even though we don't have anything in writing, this amendment is such a minor one that if I could move it and ask the committee to agree to it, then could we let this be one of those that the Honorable Attorney General would make any small changes that need to be?
It's not a consequential change, or what the chair would exercise the discretion in is that you could move it orally after asking the chair to waive the 2 days notice. So if you do that part first.
First of all, let me ask if the chair would waive the 2 days notice.
The chair is always accommodating in the interest of a
Thank
more
you.
efficient and effective
And
government. The answer is yes.
Thank you. And then all I would need to say, and I'm going to go through all the rest of it, but I want to get this out of the way first. And then the member can withdraw what his is saying, but to satisfy it, we would ask that in clause, is it 6.2? Where it has the numbers 2, where it has the number 2.
Honorable Minister.
By 6, so sorry.
Because the member from Northside, I invited him to move his
So
amendment.
let him withdraw first, okay.
That needs to be withdrawn first, so we don't
That's
have two
fine.
questions on the floor.
That's
So,
fine.
Honorable Minister, if you could proceed to ask for the withdrawal thereof.
Madam Chairman, I will withdraw the amendment that I have proposed to clause 6D.
The question is that the proposed amendment by the member from Northside to clause 6D be withdrawn. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The motion is not carried. I recognize the Honorable Minister for Planning.
Thank you, Madam Chair, and I wish to certainly thank the member from Northside for his continued cooperation.
Soon run out though.
Madam Chair, and I would ask that in clause 6.1D, that in 6.1D, the word "to" be deleted and substituted by the word "5."
The amendment has been duly moved. Does any member wish to speak to the amendment? Member from Northside.
Wanted to say, Madam Speaker, that I would like to see of the public so that the people in the civil servants can't interpret that any of those 5 could come from the
What does the 2
civil
say now?
servants. And then we need to add the rider
what the 2
about
says.
1 must be from the bride.
Sister
that
Islands.
amendment.
Sister
Let me
Islands.
see it.
Including Cayman too.
Wait.
Madam Speaker, if the member would allow me, I would proffer the wording of the amendment for him, but he could move it just to.
No, go right ahead. Let me see.
Member from Northside.
I'm just looking at the main.
The amendment would say, delete the word "to" and substitute 5, and after the word "members" add "of the public" by cabinet, one of whom shall be from the sister islands, or Cayman Brac and Little Cayman.
And then that's okay?
I would think so.
That's fine. Then we're all okay? That's fine.
Because my daughter would say, good job.
Member from Northside, since the draft proposal has been informally accepted by the Honorable Minister, can I have you repeat it for the record so that it can be accurately recorded?
That in clause 6.1D, the word "to" is deleted and the word "5" is substituted, and that the words "of the public" be added after "other members" by cabinet, and after cabinet we add the words
One of
"one of whom shall be from the sister islands," and the rest of the clause is deleted. Oh, I think you need to retain on the recommendation of the minister. The words after the minister would be deleted.
No, we can't delete the heritage and the culture and stuff like that. Can't take that out. We're not taking that out.
Oh, okay.
You don't want to take that out.
Well, I don't know how you're going to measure that.
No, you will accomplish your goal, but we don't want we don't want not to have those kinds of people there, and they can be from the public too. That's not a problem.
Yeah, no. I just have some difficulty of how you're going to measure the knowledge of somebody's background and knowledge in island heritage and culture prior to their appointment.
Yeah, it's fine with me. It's fine with me. Thank you.
The amendment has been moved. If there's no further debate to the amendment, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause. I will now put the question that clause. Honourable Minister, do you have a further amendment to clause 6?
And Chairman, I think he needs to move his amendment to subclause B
That's what
of
I
that clause. Yeah.
recognize, Honourable Minister.
Thank you. Madam Chair, in addition to that amendment for clause 6, we would like to delete clause 6B and substitute the following. B, Chairman of the Tourism Attraction Board or his or her designate.
The amendment has been moved. Does any member wish to speak to the amendment?
No, man, so I wanted to draw your attention that you can't put the vote until we get a quorum.
Could the sergeant or the government whip please assist the House or the opposition bench to get a quorum in? The clerk says we have 10. Let's move on.
Aye. We did. We did. Was a mistake.
I put the question that amendments stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 6 as amended stand part of the clause. I'll now put the question that clause 6 as amended do stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 6 as amended now stand part of the bill.
Clause 7, meetings.
We'll send you as we need.
I put the question that clause 7 stand.
Madam Chairman, I have
I beg your pardon. Member from North Side.
Thank you, Madam Chairman. Madam Chairman, I filed an amendment to clause 7, subclause 2. That where it says a simple majority of the members present at a meeting of the commission constitutes a quorum, I'd like to delete that clause and substitute a quorum shall be 5 members.
The amendment has been moved. Does the mover wish to speak to the amendment?
Especially now since you got 8 members and all.
Well, at any time, because I don't think we can have a situation where less than a majority
3
can
and
be
5
present at a meeting, but the majority of those present form a quorum.
3 and 5 is 8. We're changing 2 to 5. So 3 and 5. is
Honourable
8.
Minister.
Madam Chair, I don't have any problem with that amendment. It just dovetails nicely based on the other amendment which we just accepted.
If there's no further debate, I'll put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause. I now,
I have another amendment to that clause, Madam Speaker.
please proceed.
In clause 7(4)(b), it now reads, But let me read the whole of 4 so the public will understand. If a member of a commission has a pecuniary interest, direct or indirect, in any matter before the commission in which his or her private capacity conflicts with the member's duties, the member shall, A, as soon as practicable, or after becoming aware of the interest in the matter, disclose it to the chairman, and, if so directed by the chairman, recuse him or herself from participating in the commission's consideration of the matter. I wish to amend clause 4B by deleting the words, if so directed by the chairman.
The amendment has been moved. Does the member wish to speak further to the amendment?
Yes, Madam Speaker. I think if a member declares he has an interest, he should not have to be directed by the chairman to recuse himself and not take part in the deliberations.
Madam
That should
Chair,
be-
that's fine. We don't have to talk about that anymore.
Okay.
If
thank
there's
you.
no
Take it
further
out.
debate, I'll put the question that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause.
Because you got some more.
I will now put the question that the clause 7 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 7 as amended now stand part of the bill.
Clause 8, powers of the commission.
Honourable Minister, you have a proposed amendment.
Yes, Madam Chair, that in clause 8, subsection 3, we delete the words or licenses.
If there's no debate, I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. The amendment stand part of the clause, and I'll put the question that the clause as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 8 as amended now stand part of the bill.
Clause 9, posting signs and advertisements. Clause 10, commissioner's budget.
Put a question that clauses 9 and 10 do start part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 9 and 10 now stand part of the bill.
Clause 11, appointment of inspectors and secretary to the commission.
Honourable member from Northside.
Thank you, Madam Chairman. Madam Chairman, I have filed an amendment to 11.2, which currently reads, under the direction of the chief officer and the chief inspector, the secretary shall record the proceedings of the meetings of the commission and assist the commission and chief inspector in the administration and enforcement of the law. I have filed an amendment to delete the words under the direction
Madam
of the
Chair,
chief
we are happy
officer
with
and
the
the chief
proposed
inspector.
amendment.
If there's no further debate, the amendment has been moved. I put the question that amendment stand part of the clause. All those in favor, please say aye.
Aye.
Against, no. I believe the ayes have it.
Did I get it?
Yeah, tell them we need 2 to put the question. That's a what listing, you know.
I put the question that clause 11 as amended stand part of the clause. All those in favor, please say aye.
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 Against, no. The ayes have
You
it.
go vote for your friend amendment. It's him bringing it.
The amendment stand part of the clause. I put the question that clause 11 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clause 11 as amended now stand part of the bill.
Clause 12, designation of deputy inspectors. Clause 13, certificates of appointment or designation. Clause 14, right of public to use public land. Clause 15, carrying on a trade or business on public land.
I put the question that clauses 12 through 15 stand part of the bill. All those in
Madam Chair,
favor?
Madam Chair, I just
Member
have
from
one,
Northside.
through you, I need to ask the Minister a question.
Okay. I think we're okay.
Yesterday, we amended the trade and business license to exempt certain categories of activities that may take place here in these locations from the requirement of having a business license. I think we need to amend this because I understand it. So somebody to get a vendor's license from the commission, they have to first have a business license from the Trade and Business Board.
Honorable Minister.
So which one are you speaking to now?
I believe it has to go in 15. You need to make some. I'm not. I think you need to recognize that there will be persons or businesses who apply for vendors permits that the trade and business license do not require them to have a trade and business license. So if the vendor's permit is dependent upon a person having a trade and business license, they could not meet that requirement because they don't have a trade and business license.
Honorable
So-
Minister.
So, in order not to be confused, Madam Chair.
You might have to amend, amend 2A.
Yeah, but what I want to determine, first of all, what would cause anybody or any entity not to need a trade and business license, but to need a permit from the commission?
Because
Member
if,
from Northside.
yeah, through you, Madam Chairman, if I want to conduct one of those commercial activities under this law on public land, which do not require a business license,
For example,
artists and crafts that we exempted yesterday,
that is the amendment you're talking about yesterday.
right?
Right.
Agricultural,
Right.
Those that set up a little agricultural thing on the side don't need a business
Right.
license.
Right.
So I think, Madam Speaker, maybe it'll be easier to put it in 16(2). And but maybe we can wait, we can approve 15 and do the amendment to 16 where it's,
Okay, I was putting a question
yeah.
on 12 to 15, so I'll proceed accordingly.
Yeah. Sorry, Madam Chair, may I?
I think the member from Northside was offering a solution and that I
But-
could
but I just
proceed
want-
as I started with 12 to 15, and he wanted to do to 16, which you already have an amendment when you
Okay,
could
okay,
deal
okay.
with it at that stage. Yes.
Okay, fine.
I put the question that clauses 12 through 15 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 12 through 15 now stand part of the bill.
Madam Chair, if I might,
Honorable Minister.
to the member for Northside, just to confirm something. Is it that your interpretation of the bill itself is that anyone who is wanting to use any public land must have a trade and business license?
16(2). The commission may only grant a vendor's license to an applicant if satisfied that applicant holds or will obtain a license under section 21 of the Trade and Business Licensing Law. That's not where we made amendments yesterday. We made it to section 3 of the Trade and Business License.
Honorable Minister.
Which one? We're in the committee stage.
Clause 16.
All you're doing to 16 is
Right.
taking
Take-
the plural of a section, subsections, and changing license.
16.2, exactly. 16.2, we're not talking about a trade and business license, we're just saying. 16.2, or if member would just allow me to move 16.2.
Oh, okay, you're deleting clause,
Right.
and so,
All we're saying is
No,
that
no,
the
okay.
license that is,
right. The effect of that would be that a person could get a vendor's license without a trade and business license.
exactly, a vendor's permit.
Why?
Why? For the same reason you just said.
No,
There
but
are
that's what
those
I-
who are who
No,
are an
but-
exception.
But let's say somebody operating a water sports association, water sports facility.
Now, if you need a license, then you have to have a license. This is only to accommodate if somebody doesn't have to have a trade and business license.
But if you take out section 2 completely, right? It now says the commission may only grant a vendor's license to an applicant if satisfied that he holds, right? If you delete the requirement for a business license entirely, the way I read that is that if I'm in the water sports business, I just need to come to you and ask and get a permit to operate there, and I don't need a business license. Why? What about Cayman ownership? Because your permit does not here say you got to have Cayman ownership. We're getting enough competition there now and take over.
Yeah. Yeah. Madam Chair, it's overlapping, and I think what the member is talking about is a little bit more than belt and braces. So we have a trade and business license law.
Right.
The trade and business licensing law will tell these people who are operating, what was the example you used? Water sports
Yeah,
business?
right.
Who are operating a water sports business, that you cannot operate a water sports business without a trade and business license. Right. We are saying, we meaning the commission, why this is being deleted is because it is not the commission's remit or realm to ensure that the person applying for the permit has a trade and business license.
But
So
through you,
it is only the commission's remit to look and say, shall we give this applicant permission to use, and under what conditions, if the grant is done, if the permit is given, that under what conditions should the permit be given. So just to say to you, I think the member is saying if you take it out, then people can say they don't need to have it. And I'm saying to you that that's a whole different thing. That's the trade and business licensing law. This is the public lands law.
okay, how then will the commission,
Member from Northside.
through you, Madam Chairman, how then will the Lands Commission know whether the person has a trade and business license or not? Because here's my fear, Madam Speaker, is that you go get fronting in this business is bad enough now.
The buck stops with the Trade and Business Licensing Board, not the Commission.
Granted, but my recommendation to the Minister, Madam Speaker, is that we do not take out clause 2 because it also deals with alcohol consumption and all that, but that we modify A that says a license under holds or will obtain a license under section 21 of the Trade and Business License Law 2014 where required to do so to operate a business. Then you're safe, because the person then has to tender to you a existing trade and business license in order to get your permit. If you take it out completely, you can't ask me to prove that I have a trade and business license.
Honorable Minister.
1 second, Madam Chair. I better or better not. I'm trying to decide which one is best. Best to listen or not to. Madam Chair, just not to waste time, but because I hear what the member is saying, loud and clear. But the contention by way of the legal drafting is that this specific law, or bill rather, the aspiration to become law, is one that should not be overlapping with the trade and business licensing law. What?
Honourable member from Northside, if you give the chair a minute so that we could have a
And
transfer
this,
of the chair.
so sorry.
Thank you.
No man, I go. No matter I get my what I want you done. No worry. At least another hour. I don't know how late they can work today, but I can tell you 4:30 I go. Through you, Mr. Chairman.
Can I just tell you something?
Yeah.
This proposed amendment is based on the recommendation of the DCI. I'm just telling you.
Yeah. Madam Speaker, I don't think there is any crossover purposes here and that we're transferring any authority of the trade and business licensing people to this commission.
That's not what I was saying.
No. What this,
I hear what you said, but that's not what I was saying.
what I'm trying to get here is that people for whom a business license is required cannot get a vendor's permit to operate here without having a trade and business license.
It's the other way around. They can't get a trade and business license to operate on the public lands unless they have the permit.
Well, we amended the trade and business license yesterday. I don't recall putting that in the trade and business license as a requirement.
It's what? It's already in the law. Right, and we understand that. That's why this amendment is here. Not just that's why, but this amendment takes care of that exemption. So you don't have a problem with the exemption. We don't have to address anything to do with the exemption once this amendment is done. But what I'm saying to you is that, and I battled with them because I was where you are. I was. But it was a question of deciding which one is where the buck stops. So the buck stops at the Trade and Business Licensing Board. They cannot get a trade and business license unless they have a permit. But if you say they cannot get a permit unless they have a trade and business license, then you are tearing them in two. It's one before the other.
But suppose I already have a trade and business license.
Then when you apply, because don't forget in section 15 when you apply for a permit, you will be asked if you need a trade and business license, you need to provide it.
But they can't provide it because they're not getting the trade and business license until you get your permit.
Any person carrying on a trade or business license shall, unless excluded from the application of this law, apply to the board for the grant or renewal of a license in accordance with the respective categories of trade or business set out in Part B of Schedule 1. An application pursuant to subsection 1 shall be accompanied by where the applicant will be carrying on business in a public place, evidence of the approval of the relevant authority to carry on business in such a place. So the permit that they will get from the commission is the evidence to supply. See, I understand what the member is saying, Mr. Chairman.
But what about B, which is related to the sale of alcohol? You delete that too, then nobody can sell alcohol without.
No. They have to, they have to ask the board for permission. They commission for permission. The commission decides that. The reason why that is the case is because the commission would never grant the ability to sell alcoholic beverages on an ongoing basis. But you will have the exception, which you may well encounter, with a Pirates Week function, at which point in time the board will say, because it's Pirates Week, because it's a one-off, you may have permission.
But if you delete B, the board, your commission cannot rely on the person proving that he has a liquor license, because you're saying he don't need it anymore. You're deleting it from the law, from the bill.
Regulations.
And
No, and I understand. Mr. Chairman,
Honorable Minister.
thank you. I know the difficulty when we are seeking to pass legislation and we don't have the accompanying regulations alongside, because that clears the air, satisfies the mind, and all of that. And I know that difficulty because
a lawyer, but I don't think you can write regulations unless you have something in the substantive law that allows you to write regulations.
Section 38.
Yeah, but that refers to what is in the body of the law.
No. It just says it may make regulation to accompany it. Yeah, but you don't have to specify liquor license in the law that to make a reg that says one of the things you have to prove, one of the questions asked in your application form is will you or will you not? And if you will, do you have a license? And even if you have a license, the commission still has to decide whether they're going to grant you permission, you or anyone else rather, permission to utilize the premises and sell alcoholic beverages. I just want you to know that I understand you. I do. Okay.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those. Okay, I understand you already read the clause.
I was about to ask, Mr. Chair, and you have to forgive me. But could the clerk help us get back on track and tell us where we are now and what else needs to be done? Which clause are we at?
Clause 16, granting the vendor's license.
And I do need to move the amendment.
Yes.
Thank you.
Minister.
Thank you, sir. Mr. Chair, I move in clause 16, in subclause 1, to delete the words subsections 2 and substitute the word subsection, and to delete subclause 2 and in subclause 3 by deleting the words the license and substituting the words the proper.
The amendment has been duly moved. Does the minister wish to speak thereto?
I think these are self-explanatory.
Question is that the amendment stand part of the clause. Honorable member from the other side, apologize.
I think you need to make an amendment to 16(1)(a) if you're deleting clause 2, because it can't be subject to 2 and 3 if there's no clause 2. I think you need to delete 2 and just say subject to 3, which is just the payment of the fee.
Yes, sir. Yes, yes. They've already picked that up. Yes. In the cleanup exercise, they will take out 2 because it will no longer exist. That's what you're saying, right? The reference to it.
And he will renumber 3 as 2.
Right, exactly.
One more time, the question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question is now that clause 16 as amended stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 17, renewal of vendor's license.
Amendment, Honorable Minister, clause 17.
Yes, Madam Chair. Mr. Chair,
You're
forgive me.
getting closer.
In clause 17, by deleting the words "the license" wherever they appear and substituting the words "the permit." That's it for now.
Does the member wish to speak there too?
Straightforward.
Question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 17 as amended stand part of the bill. The question is that clause 17 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 18, late application for renewal.
Honorable Minister, amendment.
In clause 18, Mr. Chair, thank you. In subclause 1, by deleting the words "the license" and substituting the words "the permit." And in subclause 2B, by deleting the words "the license fee" and substituting the words "the permit fee."
Amendment has been duly moved. Does the minister wish to speak there too?
Aye.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question now is that clause 18 as amended stand part of the bill. The question is that clause 18 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 19, deemed extension of vendor's license.
The question is that clause 19 do stand part of the bill. Those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 19 stands part of the bill.
Clause 20, public display of license.
Honorable Minister, I think there's another amendment.
Yes, sir, Mr. Chair. I move in clause 20, in the marginal note, by deleting the word "license" and substituting the word "permit," and by deleting the words "the license" and substituting "the permit."
Does the minister wish to speak there too?
One more aye, sir.
The question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the clause. The question is that clause 20 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 21, cancellation or suspension of vendor's license.
The question is that clause 21 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 21 stands part of the bill.
Clause 22, powers of inspectors.
I understand there's two amendments, one by the minister and one by the member from Northside.
Mr. Chairman, I will withdraw my amendment to clause 22E because I think in discussion with the AG, the body of clause 2, unreasonable grounds that a person has committed, will cover my amendment. If he agrees with me with that, then that's, in other words, nobody can stop and search somebody unless
Just so.
he has reasonable grounds under the body of the clause to do so. Okay.
The question is that the amendment by the Northside member be withdrawn. Those in favor, please say aye.
Aye.
Those against, no. Honorable Minister.
Mr. Chair, in clause 22, 2C, I seek to delete the words or license and to insert before the semicolon the words or any other law.
Does the minister wish to speak there too?
No, sir.
The question is,
To
Honorable
you-
Minister of Northside.
Through you, Mr. Chairman, why are you deleting our license? That might be, if a license is required under another law, any other law, you don't have to produce it? Because I think this is not a situation where license and permit is interchangeable as you did in the opening amendment. This could be a liquor license, for instance. And if you don't put it there, the inspector can't demand it. So I think you have to leave the words "or license" in.
So if we're deleting the words or license and we're inserting before the semicolon or any other law or any other law.
I'm not a problem with that, but I'm saying is
No, but what I'm saying is or any law means whatever if a license is required under that law.
right. But the way I read it, you can't demand my license under that other law if it's not demandable under the section.
Okay.
Honorable Minister.
Mr. Chairman, I don't for a minute wish the member for Northside to ever believe that I just have to find something to argue with him about. So, in order to make him know that we are very, very appreciative of the fact that he is so diligent and careful, we certainly accept what he's saying, and instead of asking that we delete the words "the license," we would ask that to be struck off, sir, so that the words "the license" can remain. Okay?
Question is that the amendment stand part of the clause. All those in favor, please say aye.
Aye.
Those against, no. Ayes have it. The amendment stands part of the clause. Question is that clause 22 as amended stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Yes.
Clause 23, search of premises or persons. Clause 24,
I
seizure-
have a question on the 23.
Honorable member from Northside.
23.1 refers to Criminal Procedure Code 2014 revision. Is it necessary there to add our future revisions?
Goes without saying.
Huh?
Goes without saying. Once
Okay, I
it's
just want to make sure
revised.
that we're not stuck
Yes,
in that
I
time
understand.
warp of 24.
Yeah, but that goes without saying. In
Okay, that's fine.
Clause 24, seizure of items by inspector or duty inspector. Clause 25, prevention of damage to public land or facilities.
The question is that clauses 23 through 25 do stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clauses 23 through 25 stands part of the bill.
my bill. Or somebody got it. Jesus, Lord, I'm hungry.
Clause 26, carrying on a trade or business on public land without a license. Clause 27, contravention of regulations. Clause 28, obstruction. Clause 29, issuance of ticket by inspector. Clause 30, opinion of persons receiving a ticket. Sorry, options of persons receiving a ticket.
I have a question on 28.
Honorable member from the outside.
Yeah, through you to the minister. Can the minister tell me where in this bill you inserted the offenses that I was trying to create under the prescription law and the penalties in this law? Because 28 just seems to relate to the duties of the inspector. And my thing on the prescription law was where people placed obstructions in the right of way.
But, Mr. Chair, I do believe that there's an oversight. I have a second amendment that I've tabled. Yeah, what, sorry?
New clause at the end.
Right, it's in section 25A, but it's at the end. So just so that you will understand, Mr. Miller, it is here,
Okay.
and you will hear it. Thank you. I even think you'll like it. I understand.
Clause 30, options of persons receiving a ticket. Clause 31, payment of fixed penalty. Clause 32, plea of not guilty. Clause 33, summary court appearance. Clause 34, procedure in case of not guilty plea. Clause 35, filing of tickets with clerk of court. Clause 36, delivery of notices or documents. Clause 37, evidential provisions.
The question is that clauses 26 through 37 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 26 through 37 stands part of the bill.
Clause 38, regulations.
Honorable Minister, an amendment.
Which one now?
38.
38. Sorry, Mr. Chair, but the Premier is ensuring that I starve. There are two amendments. One is tabled and the other is one just brought to my attention by the Honorable Attorney General. And I'm hoping that
So
the
granted.
Chair will waive the 2 days' notice.
So granted. Waiver waived.
Thank you. In 38(1), where it reads, the Commission may, subject to approval by Cabinet. I wish for that to be deleted and to be replaced by the Cabinet may, comma, after consultation with the commission,
Could you just slow down a little
comma.
bit, please?
Sorry?
Just start that over.
Yeah, I'm going to do it. So I was only phrasing
Okay.
what I was saying to make it, and then I'll quickly explain it. You won't get lost, don't worry. So I was asking, and I'll go over it again. The very first line of section 38, in subsection 1, it now reads, the commission may, comma, subject to approval by cabinet. And we're asking for that to be deleted and to be replaced by the cabinet may, comma, after consultation with the commission. In other words, this is moving the approval from the commission to the cabinet. Thank you. That's right. The cabinet may, after consultation with the commission. And in clause 38(1)(p). Are we okay, Madam Clerk, to continue? Are we okay?
Yes, that's
Right.
written.
In clause 38(1)(p), by inserting after the word penalties, the words respecting late applications for renewal of a vendor's permit or.
Does the minister wish to speak there too?
Mr. Chair, the very first amendment that I just proffered is an observation by the Honorable Attorney General, and I do trust his judgment in that matter. And the second one is straightforward.
Does any other member wish to speak? The question is that the amendment stand part of the clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question is that clause 38, as amended, stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause as amended stands part of the bill.
Clause 39, exemptions and agreements. Mr.
Honorable member from North Side, an amendment.
To you, Mr. Chairman, given I had filed an amendment to delete A, exempt that area from the application of all or any of the regulations by the cabinet. Why do we need A when B allows the cabinet to enter into an agreement to manage the
39.
to manage the land, and with the expanded definition of public lands? Do we still want cabinet to be able to exempt an area from the application of all or any of the regulations? And you sure you want regulations or law?
Honorable Minister.
So, Mr. Chair, am I understanding that the member is saying that B covers A and A is not necessary? Is that what the member said?
That's part of the reason. I have a real concern that cabinet can exempt public land from this law.
Yeah, but
That
the
doesn't
reason,
fall under the areas
right,
that we.
the reason why A is there, let me use an example. The Airports Authority. That, all of that land is termed public land. But that entire portion of land up there is ruled under the Airports Authority law. So they will be one that will be exempted.
No.
For instance, where it says exempt that area from the application or of all or any of the regulations, the runway, the airport runway. That,
But is that still under the definition of public land, or has
Yes,
that
it
been
is.
assigned as an asset to the airport authority?
but it's still public lands.
And it is, wouldn't it be better to have an agreement there than for in a future cabinet to be able to say that Caibo Beach is exempted from any regulations of this land because some developer wants to do it next to it?
Honorable Minister.
You see, I am more comfortable, Mr. Minister, with you having to do, even if you did an agreement, I understand the reason for B. And you could do agreement with the Civil Aviation Authority that the land, you already vested it with them, so it is basically under their control anyway. I'm available. I have a small consultant firm and I'm cheap too. Compared to what I see I'm paying here, $500,000 to work out a thing, I could do that for $50,000. And I might even make a profit.
My understanding, Mr. Chairman, through you, sir, to the member, and hearing what he's saying, that the reason, and this is after consultation with the stakeholders, the stakeholders are recommending A because they feel in several instances that, for instance, if you look at, I use the Airports Authority, I used the Airports Authority example. And I'm not specifically pointing them out, but I just use it as an example. The stakeholders have said that there may well be some areas of the land that they want to, for the public lands law to apply to, but there may be some areas which are sensitive either for security reasons or other reasons, or safety reasons, which they simply want to exempt. The member is fearful of any mischief, but notice how it says. It says that the commission may, subject to approval by cabinet. I'm going to read it again. The commission may, subject to approval by cabinet. Cabinet is not going to go to the commission to tell the commission to exempt some. No, that's how the law reads.
I read it.
Cabinet is the reactor. The commission will go to the cabinet. So the cabinet will look at it after the commission makes the request to exempt that area. And that will be published in the schedule in regulations. So I hear what the member is saying, but I can only say that sometimes we can be too careful and tie the hands too tight and stop the circulation, and we need the circulation to continue. I know that's not a good analogy, but I understand what the member has said, but I believe that
Just vote down the amendment. There's a particular reason why I want it recorded that I asked for that amendment, so we just vote it down.
okay.
question is that the amendment as proposed by the member of North Side. All those in favor, please say aye.
Aye.
Those against? No. The ayes
No.
have it.
No,
No,
the
sir.
noes have it. More
There
than
is a
me.
mistake here, sir.
Yeah.
All those in favor would be voting for the member for Northside's amendment. So,
The noes have it. More you voted, there's only 2 of us over here. And I heard at least 5 on a vote.
Mr. Chair, if I thought I heard you say the ayes have it, and that's where I'm querying, sir, because it
Just let me redo the vote.
yes, please.
All those in favor, please say aye.
Aye.
Those against, no.
No.
The noes have it. I
Thank you.
apologize. The clause as amended stands part of the bill.
Yeah, I know.
Question is that clause 39 stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause stands part of the bill.
Clause 40, annual report.
The question is that clause 40 stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. Clause 40 stands part of the bill.
Clause 41, immunity.
Honorable member from North Side.
Thank you, Mr. Chairman. Mr. Chairman, I move an amendment to delete clause 41 because I have some fear that we may get into that, like how we got into with the HSC authority. Because unless the part that bothers me there is bad faith.
Honorable Minister.
Mr. Chairman, I'm very conscious of what the member has said, but my understanding from the technical staff is that this section, proposed section, reflects the changes that have been made since the difficulty was recognized with the way the HSA law was and the subsequent changes that were made to that.
Honorable member from North Side.
Mr. Chairman, the clause starts off by saying the Commission owes no duty of care to keep public lands safe for entry or use by members of the public, or to give any warning of hazardous conditions, uses, structures, or activities on such land or premises to persons entering upon, and is not liable for accidents, death, or injuries to such person extent. What happens if some of them dive tanks down on the West Bay Public Beach explodes and kills a couple people? Do we believe that we should have some duty to say that that kind of activity can't take place on the land?
This is an indemnity clause.
And you're indemnifying the Commission from any acts.
Honorable Minister.
But, Mr. Chair, the exceptions are willful or malicious failure to guard or warn against hazardous conditions, injury suffered in any case where permission to enter public land was granted for monetary consideration, or to any person who is expressly invited rather than merely permitted to enter on the public land. So the Commission owes no duty and is not liable for accident, deaths, or injuries to such persons, except, and then you have ABC, except.
Yeah.
I still think in my mind that except ABC takes care of your concern.
Honorable member from North Side.
Mr. Chairman, I still have a concern about it, but if the minister and his battery of experts and legal advisors and technical advisors sees no problem with it, then I'll withdraw the amendment.
Thank you.
The question is that the amendment be withdrawn. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Question is that clause 41 do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 41 stands part of the bill.
Schedule, form of ticket.
Mr. Chair, I just want to be safe. I do have the other amendment. Should it be after the schedule or before?
Schedule.
New clause 25A, obstruction of public right of access to or use of public land.
Thank you.
Honorable Minister.
Mr. Chair, just very quickly, there were some concerns expressed by the minister, by the member from North Side, in the prescription law when we were dealing with that. And he had proposed 2 amendments, which he has since withdrawn because we had given him the commitment that we heard what he was saying and we would deal with it in the public lands bill. But the first concern was the fact that the prescription law speaks to seeking redress in the Grand Court, and he was seeking to get it done in Summer Court. But I think yes, Mr. Chairman, the legal advice is that there can be no binding declaration that would be required for such matters in the Summer Court, and that's the reason why it says the Grand Court. But the other more compelling issue was the issue of penal sanctions. And we agree that it should not just be that there is an offense and it is left like that. But since the Public Lands Commission is who is going to be dealing with ensuring that public rights of way, etc., are dealt with properly, we are proposing a new section 25A in the Public Lands Bill with so let me officially read it. We are under the relevant standing order, Mr. Chair, asking that the bill be amended by inserting after the heading summary conviction offenses the following section with a marginal note reading obstruction of public right of access to or use of public land. And the term public land is with all the definitions. 25A1, no person shall, without lawful authority, obstruct or interfere with the right of a member of the public under this law to have access to public land, to use public land, or to exercise a public right of way over private land. And 2, a person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of $5,000 or to imprisonment for a term of 6 months or both.
The amendment has been made. Does any member wish to speak thereto? Honorable member for Northside.
One question, when you refer to without lawful authority, you are referring to things like police and your inspectors and stuff, not planning,
For
giving-
instance,
not
no.
planning, forgetting to give somebody, tell them
no.
they can't stop the fence.
No, but for instance, those persons might have lawful authority. Suppose an incident happened.
Agreed, yeah.
Police got to tape it off. Suppose there is some remedial work or some construction work that has to be done, and you have to tape it off temporarily for the safety of people. That's all that is. That's all that section without lawful authority is allowing to happen. So in other words, the commission would allow the lawful authority of any one of those agencies, whenever it is necessary. Okay? I thought you were going to say the fine should be more, but I'm not inciting you to say anything now.
No, that's the first thing I look for. I compared it to what
And
I had proffered.
And that's exactly why it is what
The
it
only
is.
thing you've left out is the $500 per day for the continued offense after conviction. I'd like to add that back in.
Honorable Minister.
Because you see, Mr. Chairman, through you to the minister,
Honorable member from Northside.
$5,000 on a piece of land that is worth $2 million is no money. But if it goes on then to say $500 per day for each day that the offense commits, then it can add up.
Mr. Chairman, you know what?
Honorable
I
Minister.
agree with the member.
Would the minister like to move a motion to that effect?
The member can move it, and I'll certainly.
Honorable member from Northside.
I don't have the clause here, but to insert after
A person who
$5,000.
A person who contravenes subsection 1 commits an offense and is liable on summary conviction to a fine of $5,000 or to imprisonment for a term of 6 months.
Well, I wanted on, so I want to put him in jail too.
No,
because-
I'm not going that far.
Okay.
If you put them in jail, they mightn't get the money to pay, and they might have to stay there. So to a fine of $5,000 or to imprisonment for a term of 6 months or both,
Right.
comma, and to continue on,
And shall, in addition to such fine or imprisonment,
be liable.
pay a fine of $500.
No, be liable to a fine.
Okay.
Be liable to a fine. Go ahead.
Of $500 per day for every day after conviction that such impediment or encroachment continues to persist.
Such obstruction.
Substruction. Oh, yeah. That's okay.
Just want to make sure the clerk has it.
Say that last part for again. After every day.
Sorry, for every day.
After every day.
So, what's up? She's up to after every day.
$500 per day for every day after conviction that such obstruction continues to persist.
Yes.
The question,
Continues to persist. Or should we just say continues?
I'm
Yeah, let's
satisfied
just
with
say
continues. Yeah.
Yeah, let's just say continues. Continues. Bam. Finito.
the question is that the motion as moved by the member from Northside be given approval. Those in favor, please say aye.
Aye.
Those against, no. Ayes have it. Amendment stands part of the clause. When it is. The question is that clause as amended stand part of the bill. Clause 25. Amended. Let me do that. The question is that the new clause 25A be added to the bill. All those in favor, please say aye. Those against, no. Ayes have it. The new clause 25A has been added to the bill. The, the clause 25A. To the new. The question is that the amendment do stand part of the new clause. All those in favor, please say aye. Those against, no. The ayes have it. The amendment stands part of the clause. The question is now that the new clause 25A as amended stand part of the bill. All those in favor, please say aye. Those against, no. The ayes have it. The clause as amended stands part of the bill. We'll take a water break.
Not yet. Schedule form of ticket.
The question is that the schedule form part of the ticket of the bill. All those in favor, please say aye. Those against, no. The schedule stands part of the bill.
A bill for a law to provide for better regulations of the use of public land and to establish a public land commission and for incidental and connected matters.
The question is that the title do stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title stands part of the bill. We'll take a quick break till the minister returns. Just two left. There was one that Kurt wanted.